Separation of power, derived from Montesquieu's Spirit of Laws 1748, dividing state power into legislative, executive, judiciary to prevent concentration and arbitrariness. In India, not in a strict sense, but adopted in functional forms with checks and balances. Aristotle first classified government functions into deliberative, that is law-making, magisterial, that is execution, and judicial, that is dispute resolution, laying the foundation of laying the foundation of the doctrine of separation of power. Principles of separation of power in India. First, exclusivity principle. That is, government is divided into three structural organs: legislative, executive, judiciary. Example: legislature make law, executive implement, and judiciary interprets. Second, functional principle. Boundaries of each organs are defined. Example: judiciary cannot legislate, parliament cannot sit in appeal over judicial decisions, etc. Third, checks and balance principle. Each organ checks and the other to ensure action remain within constitutional bounds. Example: judicial review, impeachment of judge, executive assistant to bill. Fourth is mutuality principle. That is cooperation, not confrontation. Engagement, not estrangement. Example: executive is derived from legislature. Next, strict separation of power in India. First, legislature versus executive. First, executive lawmaking and amendment power. Only legislature can amend laws under Article 245, 246 and 368. Second, control over consolidated fund. Executive cannot spend money without legislative approval. Article 266, 267. Third, no usurpation of legislative powers. Executive cannot breach parliamentary privilege. Article 105, 194. Next, strict separation of power between legislature and judiciary. First, parliamentary proceedings immunity. Courts cannot inquire into parliamentary or state legislature proceedings under Article 122 and 212. Second, judicial conduct immunity. That is, parliament legislature cannot discuss judicial conduct except during impeachment under Article 124, Part 4. No legislative overruling of judgments. Legislature cannot directly overrule judicial decisions. Next, strict separation of power between judiciary versus executive. First is cabinet secretary. Courts cannot question cabinet deliberation. Article 74, subclause 2. Second, judicial independence. Security of tenure, salary, and contempt powers shield judiciary from executive control. Article 124, 147 to 214 to 237. Third is appointment. Post NJAC case 2015, executive's role in judicial appointment is limited to formal approval of collegium recommendations. Next, checks and balance in India. Checks and balance between legislature and executive. First, legislature controls executive. For example, the executive is collectively responsible to parliament, state legislature, Article 75, 164. Second example is question hour, no confidence motion, censor motion, budget control. Example: 1979 fall of Morarji Desai government via confidence motion. Second, executive checks legislature. In this one, first example is of ordinance power, that is Article 123 and 213 when Parliament is not in session, and the second example is of power to dissolve Lok Sabha, Article 85. Next is legislature versus judiciary. First is judiciary checking legislature. Two examples. First is judicial review. Article 13 ensures law do not violate fundamental rights. Examples: Rhea single case, invalidation of Section 66A of IT Act. Second example is of basic structure doctrine. Keshavananda Bharati case 1973 limits Parliament's amending power. Example: NJAC verdict. Second is legislature checking judiciary. In this, we have four examples. First is impeachment of judges, Article 124 and 217. Example: recent impeachment motion against Justice Verma. Second example is of Article 124, subclause 1 and 126. The Parliament has the power to determine the number of judges in Supreme Court and High Court. Third example is the legislature can pass laws with retrospective effect to validate an act previously declared void by court, provided it cures the legal defect. Fourth is under Article 368, Parliament can amend the Constitution to nullify a judicial ruling. Example: 24th Amendment in response to Golaknath case. Next, executive judiciary. Executive checking judiciary. We have four examples here also. Article 13 empowers court to declare any executive order, notification or bylaws void if violates fundamental right. Article 32 power to issue writs, that is habeas corpus, mandamus, etc., directly against the executive to enforce right. Third is Article 142. It enables the Supreme Court to pass any law to do complete justice. Example: Vishaka guideline. Fourth is contempt laws to ensure compliance. Next is executive checking judiciary. First is appointment of judges by President Governor, Article 124 and 217. Second is implementation of court order lies with executive. Finally, federal checks between center and states. Parliament can legislate on state list under emergency, Article 250 and 252. Second, states challenge central laws in Supreme Court under Article 131. Example: Kerala challenging Constitutional Amendment Act, Citizenship Amendment Act 2019 in Supreme Court. Significance of separation of power with checks and balances. First, it prevents arbitrary rule. That is, division of authority ensures that no single organ exercises absolute unchecked power. Example: NJAC verdict prevents executive interference in judicial appointment. Second, protects individual liberties. Judiciary acts as a safety valve against legislative and executive overreach on citizens. Example: quashing of Section 66A of IT Act to restore digital free speech. Third is ensures legal accountability. Administrative actions are subject to judicial scrutiny to ensure they align with rule of law. Example: High Court quashed malified detention order under Article 226. Fourth is it promotes specialized governance. Each organ focuses on its specific mandate, improving overall governance efficiency. Fifth is upholds constitutional supremacy. Checks and balances ensure that even a majority-led parliament cannot alter the constitution's core identity. Sixth is facilitates corrective actions. Uh, Example: passing the SC/ST Amendment Act 2018 to reverse a judgment diluting arrest provisions. Subhas Mahajan judgment. Seventh, controls fiscal expenditure. Parliamentary control over the power of purse prevents the executive from spending without approval. Eighth, resolves federal disputes. The judiciary acts as impartial arbiter between union and states, maintaining federal balance. Example: the S.R. Bommai case, 1994. Ninth, strengthens constitutionalism, embeds respect for constitutional procedures and limits. 10th, enhances public trust. Institutional friction ensures transparency as one organ exposes the lapse or corruption of the other. Example: Supreme Court's intervention in electoral bonds case 2024. Challenges to separation of power in India. First, judiciary issues. We have six issues here. First is judicial overreach. Courts issuing orders in executive legislative areas dilute separation of power. Example, liquor ban within 500 meters of highways, 2016, and SIT on black money. Second, appointment deadlocks due to friction between the collegium and executive. Example, nearly 300 High Court judges' positions remain vacant. Third, lack of judicial accountability. The Judicial Standards and Accountability Bill has remained stalled for years. Fourth, expansion of jurisdiction through the broad use of Article 142. Complete justice. Example, judicial ban on liquor and or firecracker. Fifth, tribalization of judiciary. That is the creation of executive-led tribunals. Tribunals reduce the High Court's jurisdiction, blurring the lines of judicial independence. Sixth is judicial backlog. Pending cases over 5 crore reduce judiciary's ability to check arbitrary actions effectively. Next, we come to executive issues to separation of power. First, weaponization of agencies. Allegations of misuse of central investigative agencies to suppress opposition. Example, 400% surge in PMLA cases against political rivals since 2014. Second, influence over appointments. By sitting on files recommended by Collegium, the executive exercises veto power over judicial selection. Third, expansion of police state powers. New criminal laws, Bharatiya Nyaya Suraksha Sanhita, grant broader discretionary power to the executive for search, seizure, and detention. Fourth, excessive ordinance promulgation bypasses legislature. Criticized in DC Wadhwa versus State of Bihar 1986 as fraud on the constitution. Next, legislative issues. First, exclusion of judicial review. Legislature continues to place laws in the ninth schedule to shield from judicial review. Over 284 laws are protected this way. Second, uh, legislative encroachment. Parliament can overrule judicial decision through retrospective laws. Third, decline in parliamentary scrutiny. Example, only 16% bill were sent for committee scrutiny before passing in 17th Lok Sabha compared to 71% in 15th Lok Sabha. Executive dominance. Example, criminal law reform bills were passed in just one day without adequate debate. Fifth, excessive dele- delegated legislation. Weaken parliamentary scrutiny. Allows executive excesses. Example, EIA draft notification 2020 criticized for diluting environmental safeguards. Sixth, money bill classification to bypass the Rajya Sabha scrutiny. Example, Tribunals Act and Aadhaar Act. Way forward. Strengthen parliamentary deliberation, that is, mandatory scrutiny of bills by parliamentary committees. UK system. Second, limit ordinances to genuine emergencies with mandatory time bound legislative rectification to avoid executive overreach. Third, judicial restraint and accountability. Adoption of NJAC like reform with judicial primacy preserved. Uh, Example, UK system. Fourth, reform tribunals. Reduce executive dominance in tribunals by ensuring security of tenure, clear appointment processes, and more judicial representation. Fifth, delegated legislation oversight. Strengthen the Committee on Subordinate Legislation, mandate impact assessments, and ensure delegated rules do not dilute parent laws. As Justice Chandrachud observed in Keshwananda Bharati, uh, uh, 1973, the Constitution is founded on the bedrock of the balance between the three organs of state. Chapter 3, Citizenship. Citizenship in the Indian Constitution framework. In the Indian Constitution framework, citizenship is governed by Articles 5 to 11, Part 2 of the Citizenship Act 1955. It represents a person's legal status as member of sovereign state, entitling them to all civil and political rights. First, acquisition and renunciation. First is acquisition. Five ways of acquisition. First is birth. Every person born in India on or after 26 January 1950, but before 1st July 1987. Second, every person born in India between 1st July 1987 and 2nd February 2004 is a citizen of India, given that either of their parent is a citizen of the country at the time of birth. Third is person born in India on or after 3rd December 2004 is citizen if both the parents are Indian or at least one parent is citizen and the other is not an illegal immigrant at the time of birth. Second, descent. Born outside India to a Indian parent must be registered at an Indian consulate within 1 year of birth. Third, registration. A minor children of a person who are a citizen of India. A person of Indian origin who is resident of any country outside undivided India. A person of Indian origin who has been resident of India for 7 years before applying for registration. And the last one is a person who is married to an Indian citizen and is ordinarily resident of 7 years before applying for registration. Fourth way of acquisition of citizenship is naturalization. This is for foreign resident for 12 years who meet third schedule qualification, that is language character, become citizen. Fifth, incorporation of territory. If a new territory becomes part of India, example Pondicherry, the government of India notifies its citizen. Second, renunciation and loss of citizenship. Three ways. First, renunciation, a voluntary act where citizen of full age makes a declaration. Minor children also lose citizenship but can resume it at 18. Second, termination, uh, automatic loss if citizen voluntarily acquires the citizenship of another country. Single citizenship principle. Third is deprivation. Now we come to the next topic, that is CAA NRC, concepts and evolution. First is CAA, Citizenship Amendment Act 2019. It amends the 1955 Act to grant expedited citizenship to persecuted minorities, that is Hindus, Sikhs, Buddhists, Jains, Parsis, Christians from Afghanistan, Bangladesh, Pakistan who entered India before 31st December 2014. Second, NRC, National Register of Citizens, is register of all legal Indian citizens mandated by the 2003 amendment to identify illegal immigrants. The third is historical evolution, that is first one, 1951 NRC, prepared only in Assam to record residents following the census, aimed at identifying post-partition migrants. Second point in this one is 1985 Assam Accord. Student protests led to the cutoff date of March 24, 1971 for detecting and deporting illegal migrants. Third one is 2003 amendment, introduced the term illegal migrant and mandated the creation of a national register of citizens. Fourth point in this one is 2013 to 2019 Assam NRC update. Supreme Court monitored exercise excluded 19.06 lakh people in its final 2019 list, sparking national debate. Fifth point here is 2019 CAA enactment. Parliament passed the amendment to fast-track citizenship for persecuted non-Muslim minorities from three neighboring countries. And the last point in this one is in March 2024, the Ministry of Home Affairs notified the Citizenship Amendment rules. Now, mechanism for implementing CAA rules 2024 to 2026. First point, the implementation follows a completely digital, decentralized process bypassing state government discretion. Second point, application must apply via the Indian Citizenship online portal or mobile app with self declaration of origin. Third point, relaxed documentation. It accepts any document showing entry before 31st December 2014, even expired passports, yeah, visa, or locally reputed certificates. Fourth is District Level Committee (DLC), headed by Superintendent of Post. This panel verifies documents and administers the oath of allegiance. Fifth is Empowered Committee (EC), led by the Director of Census Operations. This central body reviews DLC recommendations and grants citizenship. Sixth is language test. Applicants must prove proficiency in any language listed in 8th schedule of the Constitution. Seventh, direct issuance. Citizenship certificates are issued directly by the Election Commission, removing the previous role of state district collectors. Next, justification of CAA NRC. First, historical responsibility. India's moral obligation to minorities left in the theocratic neighbors after the 1947 partition. Second point in justification is religious persecution targets specific countries where the state religion, that is Islam, leads to systemic persecution of minorities. Third point is reasonable classification. That is, Article 14 allows reasonable classification for a specified group, persecuted minorities, to achieve a legislative goals. Fourth, national security. NRC helps identify illegal infiltrators who may pose a threat to national internal security. Fifth, democratic protection, that is, protects the cultural and linguistic identity of indigenous populations, especially in Assam and Tripura. Sixth point in justification is resource management, ensures that welfare benefits and state resources are reserved for genuine citizens, not illegal migrants. Seventh point is humanitarian relief. It provides a life of dignity and legal identity to 31,313 documented refugees. Eighth, regularizing migrants. That is, CAA grants retrospective citizenship, closing pending legal cases against those who fled persecution before 2014. Ninth, civilizational ethos. It aligns with India's history as a natural home for those fleeing religious oppression, example Parsis, Jews, etc. 10th point is legal clarity. It distinguishes between refugees, that is fleeing persecution, and infiltrators, that is economic migrants, streamlining the naturalization process. Now, coming to the criticism of CAA NRC, the first is religious discrimination. Critics argue CAA violates Article 14 by using religion as a criteria for citizenship. Second, exclusion of Muslims. It excludes persecuted Muslims sects like Ahmadiyya in Pakistan or Hazaras in Afghanistan from the fast track process. Third is regional refugees. It fails to address non-Muslim neighbors like Sri Lankan Tamils or Myanmar Rohingyas. Fourth is Assam Accord violation. CAA 2014 cutoff contradicts the Assam Accord's 1971 cutoff, causing fear of demographic shift. Fifth point is NRC documentation burden. Millions of poor citizens lack birth certificates. Assam NRC 2019 excluded 19 lakh people due to paperwork. Sixth point is statelessness risk, that is, fears that Pan India NRC could render marginalized Muslims stateless if they cannot prove ancestry. Seventh point is secularism at stake. That is, critics view religion-based citizenship as a threat to the basic structure of Indian constitution. Eighth point is diplomatic friction. It has caused intermittent strains in ties with Bangladesh and Afghanistan over persecution narratives. Ninth, arbitrary cutoff. The 31st December 2014 date is criticized as lacking a logical or scientific basis for determining persecution. Tenth point is financial cost. The Assam NRC cost 1,220 crore. A pan-India exercise is estimated to cost billions without guaranteed accuracy. Next, Supreme Court judgments. The first one is Sarbanand Sonowal versus Union of India 2005 case. It struck down the IMDT Act, calling illegal migrants from Bangladesh an external aggression against Assam. Second point in Supreme Court judgment is Assam Milita Mahasangh 2024 upheld Section 6A of Citizenship Act, validating the 1971 cutoff specifically for the state of Assam. Next is way forward. First, inclusive amendment. The government could consider adding persecuted sects within Islam to make the law religion neutral and legally robust. Second, using the NPR, National Population Register, data to simplify citizenship verification without requiring 50-year-old paper records. The third is India must sign a formal repatriation treaty with Bangladesh to handle those identified as foreigners by the NRC. Fourth, transparency in NRC, that is, establish clear, lenient evidentiary standards for the poor and illiterate to prevent accidental mass statelessness. Fifth, enacting a comprehensive national asylum law to provide a transparent framework for all refugees, regardless of country or religion. Sixth point is strengthening foreigners tribunal with judicial oversight. We come to the chapter 4, amendments and basic structure. Under Article 368, the Parliament is granted the power to amend the Constitution by way of addition, variation, or repeal of any provision. Amendment procedure in detail. First one, initiation. A bill for amendment can be introduced in either house of the Parliament, but never in state legislatures. Second, it can be introduced by a minister or a private member and does not require prior presidential permission. Third, special majority. The bill must be passed in each house by a special majority. That is, a majority of the total membership of the house. Second, a majority of not less than two-thirds of the members of the house present and voting. Fourth point, each house must pass the bill separately. There is no provision for a joint sitting in case of deadlock. Fifth, state ratification. If amendment seeks to change federal provisions, for example, election of the president, powers of Supreme Court, High Court, or 7th Schedule, it must also be ratified by legislatures of at least half of the state by a simple majority. Sixth point, presidential assent. The president must give assent. They can neither withhold it nor return the bill for reconsideration, as per 24th Amendment 1971. Significance of amendment. First one, ensures the Constitution remains a living document that adapts to the evolving socio-political and economic realities. For example, 101 Amendment to modernize India's complex tax structures. Second, social engineering. For example, the 103rd Amendment provides 10% reservation for economic weaker section. Third, correction of anomalies. Allows for state to correct judicial interpretations that may hinder urgent national policy goals. Example, First Amendment created the ninth schedule to protect land reform laws from judicial review. Fourth point, federal balancing. It provides a mechanism to negotiate the power sharing balance between the center and states. Fifth point, rights evolution. Example, the 86th Amendment made the right to education a fundamental right under Article 21A. Sixth point, institutional reforms. Example, the 121st Amendment, though struck down, attempted to create a National Judicial Appointments Commission (NJAC). It was 99th Amendment. Okay. Limitation of amendment powers of Parliament. First, procedural limitations. These are explicit constitutional conditions laid down in Article 368. So procedural limitations, first point is special majority requirement. Second point is separate approval by each house and no joint sitting under Article 108. Third is ratification by half states for federal provisions, for example 101 amendment. Fourth point is presidential assent under Article 368 subclause 2. Fifth point is bill must follow all legislative procedures, that is notice, debate, quorum, and voting. Procedural irregularities can invite judicial scrutiny. Example, as per Rajnarayan versus Indira Gandhi 1975 case. Next, substantive limitation on amending power. These are judicially evolved constraints that restrict Parliament from altering core identity of the Constitution. First, doctrine of basic structure. Keswanandan Bharti versus State of Kerala 1973. Second, limited amending power itself is basic structure. Minerva Mills 1980. Clause 4 and 5 of Article 368 inserted by 42nd Amendment were struck down. Okay, third point in substantive limitations is IR Coelho case. IR Coelho versus the State of Tamil Nadu 2007. It held that even laws placed in 9th schedule are open to basic structure review. Fourth point is Parliament cannot amend or abrogate or emasculate fundamental rights forming part of basic structure. Fifth point, Parliament cannot alter the essential federal balance between center and state. That is given in Kuldeep Nair versus Union of India case 2006. Other criticisms. First, frequent changes. With over 106 amendment in 75 years, critics argue the constitution is amended too easily compared to US. Second point, central dominance. State legislatures cannot initiate amendments, leaving them dependent on the center's political will. The third is ambiguity of basic structure. Since the Supreme Court has not exhaustively defined basic structure, it leads to uncertainty and potential judicial overreach. Fourth point is no joint sitting. A small minority in Rajya Sabha can block a critical amendment favored by a massive Lok Sabha majority. Next, major Supreme Court judgments related to amendment. First, Sankari Prasad case, 1951. It ruled that Parliament can amend any part of the Constitution, including fundamental rights. Second, Golaknath case, 1967. It reversed the previous stance, ruling that fundamental rights are transcendental and cannot be amended. Third is Keshwanand Bharti case, 1973. It created the basic structure doctrine, limiting the Parliament's power. And the fourth one is Minerva Mills case, 1980, that reaffirmed that Parliament's power to amend is limited and cannot be used to grant itself unlimited power. Last part in this is major amendments in Article 368. The first is 24th Amendment 1971. It clarified that Parliament can amend any part of the Constitution and made it obligatory for the President to give assent. The second is 42nd Amendment 1976. It attempted to declare that there shall be no limitation whatever on the constituent power of the Parliament. This was later invalidated by Supreme Court in Minerva.